Hello friends, welcome to Analytics IAS Academy. My name is Pankaj Shukla and today I am going to discuss with you people one important article of Indian Constitution, that is Article 20. So friends, Article 20 of the Indian Constitution is a protection for all individuals, citizens as well as non-citizens against coercive power of state. So friends, state has power to punish individuals on various grounds for violation of law. Aim of Article 20 is to ensure that state does not misuse the power in punishing individual. So friends, why state have such coercive power? So the aim of such coercive power is to maintain law and order in society. Without this power, probably state may not be able to carry on day-to-day administration in country. However, such power can be misused, and in order to prohibit state from doing so, Article 20 has been included in Indian Constitution. So such protections is a part of all democratic constitution in the world, where Article 20 inhibits state in relation to conviction for offences. So Article 20 enforces three types of restrictions on state. One by one, I will tell you people what are these restrictions. Then one by one, we will discuss these restrictions in detail. So Article 20 clause 1 says that it prohibits state from enacting ex post facto legislation. Article 20 clause 2, it prohibits state from providing double jeopardy, and Article 20 clause 3, it prohibits state from compelling an accused to provide self incriminating evidences. So these are three protections provided under Article 20 against coercive power of state. Now, one by one, we will try to understand what is the meaning of ex post facto legislation, what is the meaning of double jeopardy, and what is the meaning of self incriminating evidences. So friends, Article 20 clause 1 says that no person can be punished for the commission of an offence unless such an act is an illegal act in law books at the time of commission of the act. In other words, a person can be punished only for commission of an act which at the time of commission is declared as a criminal act by law book. An act which at the time of commission was not an illegal act cannot be subsequently made illegal. An individual cannot be punished for the same act. So here, objective is to prevent state from doing intentional conviction or to protect the liberty of individual, and for that person, for if you have to be punished in a court of law for commission of an illegal act, then such an act must have been an illegal act in law books at the time of commission of act. An act which was not illegal at the time of commission cannot be subsequently made illegal. An individual cannot be punished. So in other words, it says that criminal laws, they should be given prospective effect and they should not be given retrospective effect. So ex post facto legislation means enacting a law and giving it a retrospective effect. A state can do in case of civil legislation, but they cannot do it in case of criminal legislation. So for example, suppose smoking in public is an illegal offense since October 2007. सो वो लोग जिन्होंने अक्टूबर 2007 के पहले स्मोकिंग की, परंतु इस लॉ के आने के बाद उन्होंने स्मोकिंग करना छोड़ दिया, such individuals they are outside the purview of such law. Only those people who will be smoking at public places after commencement of this act, they can only be prosecuted. So criminal laws, they should not be given retrospective effect. Criminal laws, they should be given prospective effect. इसका दूसरा मतलब ये भी है कि no person will be given punishment more than what was prescribed in law book at the time of committing crime. So जब आपने कोई क्राइम किया है उस समय जो मैक्सिमम पनिशमेंट अवेलेबल था कानून की किताबों में, उससे ज्यादा पनिशमेंट आपको नहीं दिया जा सकता. दैट इज ऑल्सो अनदर मीनिंग ऑफ प्रोवाइडिंग प्रोटेक्शन अगेंस्ट एक्स पोस्ट फैक्टो लेजिस्लेशन इन क्रिमिनल केसेस. नाउ फ्रेंड्स, आर्टिकल 20 क्लॉज 2 it says that no person shall be punished more than once in court of law for commission of single offense. So if you committed one illegal act, you can be punished only once. You cannot be punished twice for commission of same criminal offense unless person again commits a criminal act. He cannot be punished more than once. So principle of double jeopardy, it is only applicable in case of judicial bodies and in case of judicial decision. It is not applicable in case of non-judicial bodies and in case of non-judicial decision. For example, if a civil servant, he has been convicted in court of law on charges of corruption, so merely on such conviction in court of law, his or her parent department may dismiss him from his service. Such dismissal from his parent department does not amount to double jeopardy. It does not amount to double punishment because his parent department is not a judicial body and his dismissal from the job is not a judicial decision. So friends, such protection against double jeopardy, it is applicable only for judicial bodies and only in case of judicial decisions. Now, Article 20 Clause 3, it says that if a person is an accused in a crime, then he shall not be compelled to make a confession or to give a statement, and merely on such confession, security agencies or investigating agencies, they will not procure punishment for the same individual. It means your statement, your confession cannot be used in court of law for procuring punishment against yourself. So confession made by accused to the police officer is not admissible as an evidence in a court of law. Police and investigating agency, they should duly complete their investigation. They should try to establish such charges in court of law, not merely on the basis of confession made by individual. So friends, if a person can be compelled or can be convicted merely on the basis of confession made by him, then probably it will be very easy for investigating agencies to complete investigation in such cases. So in order to protect you from intentional conviction, in order to prohibit state from misusing its coercive power, Article 20 has been added in Indian Constitution, where it is trying to protect individual from ex post facto criminal legislation, from double jeopardy, and from self-incriminating evidences. So friends, I think I made this article clear to you people. If you have any doubt, you can write your comments and doubts in description box. Thank you.